Mark, you are streaming live.
All right, so I get on my phone here.
So Mark, you're not a coffee drinker, so.
No, I'm a morning person, so I wake up, I'm already relatively wired, ready to go as it is.
Definitely need my coffee in the morning.
All right, are we got 8 o'clock? Ready to go?
It's 8 o'clock.
Everybody? All right, Glenn, looks like we have a good crew here joining us here today. You have to go and move. Turn it on a timer, just hit the button. My lights went off because we're on a different spot of the office and the motion activated thing went off. Did you close my door? Thank you. Thank you. All right. Good morning, everybody. Welcome to this week's Community Cafe. We are live on zoom.com and we are also live on Facebook Live. Our committee, our cafe committee is made up of Chris Tillman with First Option Bank. We got Glenn Stockton of Stockton and Stern Law Firm, and myself, Mark Roberts, owner of Affinity Asset Management. Today's topic is estate planning for blended families and remarriages. So do me a favor, for those of you who are following us on Facebook, click the share buttons and share us with your loved ones, the people in your life. And then when you get a chance, go out to our Community Cafe Facebook page and like us, so that way you can follow us on that from now on, and that way your friends get a chance to always follow as well. Next week's topic, we got a juicy topic for next week. It's talking about a trusted advisor. Now, a trusted advisor could be somebody like me, a financial advisor, your banker, your attorney, but are they a salesperson or are they a business owner? So that's what the topic is going to be next week. Is your trusted advisor more of a salesperson or more of a business owner? Today with me, I got Glenn Stockton of Stockton and Stern. Glenn, both have lots of clients that we got good stories to share, some bad stories to share regarding how things have been handled in second marriages and in blended families. So Glenn, welcome. Thank you for joining us here today.
Thank you. Good morning. So I enjoy doing these.
Yeah, I do too. So Glenn, why don't you start us off here talking about, from a legal perspective, stories that you can maybe share with us, good stories, bad stories regarding blended families, marriages, just planning that needs to be done. Sometimes it's done and sometimes it never gets done.
Yeah, I think, it's something just in the years I've been doing this, seeing the increase in number of people that are in blended families. Remarriages has always been something common, but now, it's become certainly at least half the number of cases that we do, if not more, are blended family situations. Either there's been a remarriage at some point, maybe a long-term marriage, but they were, had children in prior relationships. Maybe it's a short-term marriage. So the remarriage and second marriage issues are pretty prevalent. It's what prompted me, as many of you know, to become an estate planning attorney. It's what happened to my family when I was, before I went to law school. My grandfather remarried after my grandmother's death, and all the assets ended up going to that new spouse. And I thought, well, how did that happen? Because I don't think that was the intent. It was an accidental disinheritance. So I took a lot more interest in estate planning, I think, when I got to law school than I might have otherwise done. When we get, there's no right or wrong answer. I think that's the first thing to understand. It's going to be unique to each family. But let's talk about some of those issues that come up that if we're not aware of them. The first one could be with joint tenancy issues where, a married couple, they title accounts as joint tenancy. And don't think about the consequences of that. And we just, people all the time, they'll title the home in the joint names with their new spouse or their bank accounts. And in those situations, when they die, it doesn't matter what their will says or what their trust says or anything else. If that account was owned as a joint tenant and they die, the spouse or whoever is the joint tenant on there is now the new owner of this. And their will or trust has no effect on that. And that can be true with homes, vehicles, bank accounts, everything. when we provide for just outright distributions, a lot of people, they go into marriage and then they sign a will and says everything to my new spouse, and then they're going to divide it up among the spouse's children and their children at death. And oftentimes that doesn't end up happening, because once you die and you leave it all to your spouse, now it's subject to they can change beneficiaries, they can, and sometimes they're being encouraged to do so by their kids, or just kind of a lot of things can happen, and all of a sudden your kids are left out. If long-term care spin down, if this is when you're still alive, if you bring assets into the marriage, one of the spouses brings more assets than the other, and now the one who had lesser assets ends up needing long-term care at some point, needs to go in nursing care. The spouse who brought in more assets is now subject to a Medicaid spin down. Their assets are marital assets, are considered available resources. So we've got issues with that. Beneficiary forms, we leave our IRAs completely to the new spouse. Well, there's nothing necessarily wrong with that. Just be intentional about it, because it's your death, the spouse ends up, because your beneficiary designation is controlled. Doesn't matter what the will said, doesn't matter what the trust said. And finally, the other big issue we see is just increased family conflict. After the death of one spouse, the children of that spouse having conflict with the other spouse. And we see these all the time. So, a recent story that kind of included a lot of these things that went in that I was aware of. This mom had remarried. She brought more assets into the relationship than the husband. They were married for a number of years, probably close to 20 years, but she brought more assets in. She then also inherited assets from her mom when her mom died. They brought in additional assets, and she had never done any planning. And so then upon her death, everything ended up going to the new husband. And that worked okay for a while. You could see cracks in there. The kids were, her kids were a little bit upset that they didn't receive any inheritance. So I don't know if it was a sense of entitlement, or they thought they should have received some. But then the new husband decided he was moving and brought in one of his children into the home. That child lived there for a while, then ended up taking a lot of the family belongings that had come down through the family with him when dad decided he was moving. And so his child ended up with a lot of the assets. He then took everything he wanted, and the mom who died, her kids were allowed to come in and pick over what was left before it went to sale. And at that point, there was a big family blow up. And so I heard all of this because I know this family to some extent, and it was just a sad thing to see. And it was because there was no planning, there was no communication. I don't know, it may have been, the mom's intent that, hey, it goes to my husband, and what he does with it, I don't care. But probably at the minimum, what I tell people in long-term care, one, enter into prenuptial agreements, premarital agreements before you enter into the new marriage. Talk to your kids, make sure that everybody's clear what's going on, and then see an attorney. And there's a lot of things to do. There is no cookie cutter recipe, right answers, wrong answers. It's what you want at the end of the day. So that's kind of big picture of what I guess this topic sees. And Mark, I know you see a lot of this stuff too. I mean, with beneficiary designations and spouses, and I'm sure you could tell a lot of stories about situations where there were what we would call accidental disinheritances, or at least appear to be accidental disinheritances.
Accidental or just misplaced trust. I mean, we got lots of bad stories to kind of share on these. And when I say bad stories, it's always the same thing. It's one spouse's kids being cut out. I mean, that's really what it boils down to. I would say the most common thing is when people get remarried, and they could have been married for quite some time. It could be a relatively long-term second marriage, but they don't share the same kids. So they have blended families. They have kids from separate, the first marriages. And so, as this couple age, they make sure that they are each other's beneficiaries on everything. So they'll contact us as the financial advisor and say, okay, I want to make my spouse first beneficiary and my kids the secondary beneficiary, which is very common in lots of things. Now, like for Amy and I, that would not be a big deal because we're first marriage and been married for 26 years. And so we should be each other's first beneficiary and our kids should be second beneficiary. But, let's say we were divorced and Amy or I, we got remarried, and now we've been married 10, 15 years, whatever. It's kind of just natural to make your new spouse the beneficiary of stuff because you want to provide for them. In the event that we die or die early, you want to provide for them. But what I try to get people to do is understand that if we leave everything to your spouse, and then by the time your spouse dies, it's your spouse's money, it's in your spouse's accounts. It's no longer required to go to your kids. You might have an agreement that upon that death, they're supposed to give that money back to my kids. They don't have to. So I encourage them to go see an attorney, go see somebody like you, so they can actually put that in writing, so that it spells out, when I die, I want my assets to go to my second spouse, and I want to provide for that person. But upon the second spouse's passing, it goes all back to my family, not to, let's say, her kids. And I would just say accidental trust. They just don't think that kind of stuff through on the logistics of it. So people sometimes, I find, fight me a little bit on wanting to go back and see the attorney or to go see an attorney because, oh, I don't want to spend, a couple $1,000s with an attorney to get an estate plan. My stuff is simple. I don't have a lot of assets. I got beneficiaries on everything. So we see things like that. But really, when you have second marriages and blended type families, that is really the only way to do that. Is I can't put that in a beneficiary form. There's just no way on IRAs and 401ks and life insurance. We can't put this stuff properly on a beneficiary form that accounts for the various scenarios of who dies first and do I provide for my second spouse? When does it go to my kids? So it needs to be done legally with somebody like yourself to create those documents. And I'm assuming that's what you're referring to, the same thing, right?
Yeah, no, it's first thing. And it starts really in that second marriage situation. What I would encourage people is get the premarital agreement, the prenuptial agreement, and make sure you address these issues, that you go in, that the spouses both know what their rights and obligations are. I mean, if one of them comes in with the expectation that they're going to inherit everything, is it understood that, hey, we're going to keep separate assets? This all needs to be spelled out in a premarital agreement. Rights and responsibilities during the marriage with regard to living arrangements, what's going to happen in the home, division, and obligations to pay expenses, spell that kind of stuff out. And then also, is there an obligation or expectation that each of the parties are going to maintain long-term care insurance, life insurance? We can easily provide for both parties. We can purchase life insurance. It just needs to be spelled out. Not only the rights and obligations, what happens if they divorce, which is what most people, I think of when they think of a prenuptial. Oh, that's in case I end up getting divorced. But a prenuptial agreement can also talk about rights and obligations of the surviving spouse when one of them dies. What right do they have in the estate? And those things should all be spelled out. So if entering into a second marriage or contemplating that, I would, tell you got to get this done. Think about it, communicate, spell it all out, and don't just enter into this blindly. But you're absolutely right, Mark. We see this all the time. They go in, they don't put the prenuptial agreement together, they get in, and they don't think through thoroughly enough, and they're naming beneficiary designations or everything to spouse with the idea that everything's going to work out like they want. And even when that trust is well placed in our spouse, and we know our spouse wouldn't do that, sometimes they lose control. If they end up needing a conservator appointed at some point who is managing their assets, that conservators manage it for their benefit. Your kids don't enter into the picture anymore. And so, there's a lot of things that can happen that could easily be avoided with, a properly executed estate plan and really, hopefully, that prenuptial. But if not, well, then let's get this agreement spelled out through estate planning documents, a kind of post-nuptial agreement that will address this.
So let me kind of ask you from this perspective. A lot of people that are going to be watching this on Facebook Live are not clients of mine, clients of yours. So it's easy for me to talk about this from my angle, because when I have clients that are divorced, they get remarried, I know how to address these topics and to tell them about the pros and cons of the various things that can happen. But ultimately, I have to send them to an attorney like yourself to create the documents to get this thing in order. So I was going to flip it over to you is, because you work with lots of different financial advisors that are out there like me, how often would you say, like, what percentage of the time is their current financial advisor bringing up these issues to them, or is it more you're bringing up the issues to them when you find them?
Yeah, unfortunately, most of the financial advisors, insurance agents, they're not. I don't, it's just not on their radar screen necessarily.
That's what I thought.
Yeah, they're just not addressing those issues.
So the red flag that goes up for me on that is you're talking to people about this, and you're the one bringing up these sensitive issues and how to overcome them and kind of work through what the options are, the pros and cons of those options. Can you imagine how many people are out there that work with financial advisors, or they're the kind of person that are like a do-it-themselfer? They manage their own investments, they do their own thing, and they never get a chance to see you. So if they're not doing it for themselves because they don't know this stuff, and they don't have a financial advisor, like you say, or not bringing this up, and they're not clients of yours, it's just not getting done. So I just find that there's a lot of misplaced assets that go to the wrong set of families. And I've just had in my 24-year career, money that I expected to go to these clients' kids, and sometimes they don't. They go to the new spouse's kids who are not my clients, because the husband and wife didn't put these plans together. And there's only so much I can do with a beneficiary form as a financial advisor. It really needs to be done in the legal documents. So yeah, I had a feeling you were going to say that it just doesn't happen. And as you say, financial advisors are just not bringing this up. And in my book, whenever I sign the inside cover of my book to folks, I always say that the biggest fear we all have is that we don't know what we don't know. So if we don't know this stuff, and we don't have a financial advisor ever bring this up, and they don't think they need to see an attorney, they got maybe a basic will, but they don't have anything else. Yeah, that's where a lot of assets go unclaimed, or they go to the wrong direction. And it's just scary. A lifetime of savings and building things up, and it just doesn't go to the proper people.
One of the things that there's conflict with these. So we enter into the second marriage, and even where they've had these discussions, maybe entered into prenuptial agreement beforehand. Over time, things change. Their feelings change to some extent. They want to make sure that their spouse is taken care of, and so with proper planning, we can make sure that we hit the goals, right? Whatever those goals are. And one that I'm working on currently is that situation. It's a fairly recent marriage. They were both married previously, both have kids, both own real estate, but one of them's, the real estate is out of state. And so the one spouse wants to make sure that if she dies first, her husband has a right to continue to live in the home, but she ultimately wants that home to go to her kids. And so, through trust planning in that situation, it's very easy with a trust to give a right of occupancy to that new spouse, that during his lifetime, he's got the right to continue to live in the home. But if he needs to go into nursing care, it's not subject to a Medicaid lien being thrown on that home and the state taking the home. If he dies and still living there, it doesn't end up going to his kids. It's owned by her trust, and he just has a right to occupy and live in it. And we can do the same things with making sure that there's money available, income that comes to help assist a spouse. But you've got to think about this stuff. And this really, I guess, fits well into next week's topic, Mark, that you introduced, where are you working with really trusted advisors, people who understand this stuff, are thinking about this stuff. And I think a lot of times there's just not incentive among those people to do so. But they're not saying you go to open your bank accounts. Your banker's not asking you, well, are you sure you want to put your new spouse on this account with you as an owner? Because here's the consequences. They're not telling you that. And your insurance advisor is not telling you that when you put it on your life insurance or whatever. Your financial advisor is not telling you when you stick them on your IRAs or different accounts. As a general rule, they're not telling you that. So work with advisors who understand this stuff and have your best interest and have those discussions. And as you said, sometimes they don't really want to have that discussion. That's fine. I just tell them, go into it. There's no right or wrong answer. Just go into this with your eyes wide open and understand what the consequences are if you don't do the planning. Keep it simple. That's my kind of thing on all the planning. Don't overcomplicate this stuff. Keep it simple. And if you want to make sure it goes to spouse, there's so many options. I mentioned earlier, purchase life insurance. Well, it really depends on age and that kind of stuff. And there's an expense.
And health and cost and
all those kind of things. But maybe that's the solution. There's no cookie cutter approach to it, as I've said several times now.
And yeah, everybody's situation is different. The thing is, you have to just discuss it. What do you want? What would you prefer to want? If you could wave a magic wand upon your death, how do you want things handled? And okay, what do we got to do to put that into place? So Glenn, I was just thinking, as you were talking there just a minute ago, I just realized this, there's a lot of people that watch this on Facebook or on Zoom, and they're not in second marriages or blended family situations, but somebody who is. And so everybody who's watching this, do me a favor, please. I said it earlier, but I'm going to say, share this on your Facebook, and make a note when you share this. This is the content we're talking about, how to handle things upon second marriages and blended assets, or blended families, because we all know tons of people out there who have been divorced and widowed and remarried and that sort of stuff. So please share that, because there's a lot of people out there that could, hopefully benefit from this. And I would always say, questions like this, you need to direct this back to your financial advisor or your attorney. And if you don't have an advisor that you feel like you trust on this particular topic, then reach out and give me a call. You can reach out through me on Facebook, go to our community cafe page, just look me up on my website, do the same thing. You talk to Glenn and reach out to him through his website or through community cafe. Reach out to either one of us. We're happy to help folks out there. So having shift gears in this, Glenn. So let's not talk about death for a minute. Let's talk about being alive. All right. So second marriage, blended families. I find that most of the time it works best to try to keep assets separate. Her assets, his assets, but there's always going to be some commingled assets that happened over time, like some bank accounts, the house, maybe certain investment accounts that are not retirement accounts, things that can start to be commingled. And I'd like to say, as a financial advisor, I think that's fine when things are discussed to have certain assets commingled, but it's also very fine to make sure other assets are kept separate. And it's not just for you guys re-divorcing or one of you dies and having to deal with the kid issues on either side. It's just there's other things that come up down the road. And it's always good to have the boundaries of who brought what into the marriage and keeping that separate. If you keep that stuff separate and not mingle it, it's going to be easier to identify it later down the road. And basically, we're just trying to protect all of your prior life's savings, all your prior life before this second marriage, everything that you've built and saved. We want to keep that stuff identified so that we can protect that and then protect your family to get that stuff. So Glenn, what's your thoughts and comments on, okay, it's not about death. Now it's about being married, keeping things separate versus okay to maybe commingle certain things.
I go back to, there's not a definite right or wrong answer. It's going to be specific on the desires of my clients, but it's just having the plan. So let's say we've commingled things or whatever. That's okay. We can easily set this. And this is something I talk to every client I have when we do estate planning, is what happens, because as you talked about, well, what happens, you got a long-term marriage and the people that have divorced. But what happens for many people who they're never going to divorce, their marriage is solid. When one spouse dies, if we look at the statistics of the number of people who remarry after the death of a first spouse, especially men, but women remarry at a pretty high rate too. I mean, that the numbers are much more, likely that you'll remarry than not remarry, after the death of a spouse, unless it's very, very late in life. So making sure that we have those plans in place. And it's just, and be intentional. So let's say they commingled their assets. The listeners here, they didn't get the premarital agreement together. They didn't keep separate finances. They're already in their second marriage. Fine, we can easily fix that. Now it's going to require a trust. I cannot do it with beneficiary designations. Well, not necessarily true. We can divide things out now, but as a general rule,
with beneficiaries, it becomes a nightmare. So it really needs to be done on a trust.
Yeah, well, I mean, there are times where that can still work, but most of the time we're looking at trust, and we can say, look, everything's joint property during the marriage, but as soon as one of these spouses dies, that's when we're going to divide. We're going into the division, and we're going to create the family trust. Maybe have half the assets go there, half the assets go to the survivor trust for the surviving spouse, and we can set all that up. At the end of the day, proper planning is making sure that your assets go to who you want, when you want, the way you want, with the least amount of cost, taxes, and complexity involved. And a proper estate plan should address that. And we can easily do that. But you need to, as you said, you need to get with your advisors and make that happen. Don't leave this to chance. Don't put it off, because tomorrow is not guaranteed for any of us. You got to get this planning done. If you don't, we're going to see family conflict. We're going to see hurt feelings with the kids. We're going to see, where we just got a mess and now we're a burden to our loved ones. So just get the planning done. Hopefully you did it before you entered into the second marriage, or upon when you're, in a blended family. There's just things you got to do. You've got to, premarital will be one consideration. Update your existing documents. It's amazing to me how many people get remarried and they never update their wills or estate plan, or how many people divorce and never update their estate plan, and they still have their ex-spouse named as their agent under the power of attorney and beneficiaries on forms. And there's some laws to protect, but just get that stuff updated upon remarriage. And so those would be a couple of the big things. Update your beneficiary forms and work with advisors who look at this holistically. You don't update your estate plan over here and then go do beneficiary designations over here, without.
They have to coordinate.
Yeah.
And I think that it has to coordinate. And I think people, if I can give some advice on this, don't just trust your advisor, your financial advisor, in the sense of, okay, I'm going to update the beneficiaries. If that advisor isn't making it obvious that the accounts they manage for you needs to be coordinated with the work that your attorney is doing or had done already for you on the estate plan, then it kind of should throw up a red flag, because they're just trying to tell you, yeah, we'll update the beneficiaries, but maybe there's more to it. It's more than just updating the beneficiaries. It needs to coordinate with your estate plan, because you don't want to have beneficiaries saying one thing and the estate plan, the will, or the trust say something else. So Glenn, I'm not going to put you on the spot, but there's a rumor about you, little rumor. And I don't know that I've ever really talked to you about this before, but the Glenn Stockton prenuptial agreement, pretty sticky, pretty mean, pretty concrete. And so I've had situations where I've had folks get remarried, and they need to get a prenuptial agreement, and sometimes it's not a big deal. But talking about a prenup is just kind of almost like a taboo topic. It's kind of like, I want to get married to you, but I want you to sign this document because I don't trust you and I want to protect my assets. And it's a very awkward conversation. Trust me, I've had this conversation lots of times with folks that got remarried. So one of the things I always encourage people to do is, you're married today, you're in a good marriage today, go update your estate plan and make sure there's language in your estate plan that talk about, in the event of a divorce or a death, that if there ever is a remarriage of one of us, that a prenup is required. Put it in your documents. So if you do ever get remarried later in life, you're not the bad guy. You're basically telling the new spouse, hey, my estate plan was done years ago, and my language is put into my estate plan years ago that I am required to have a prenup. Kind of just takes away some of the, the distrustness, I guess you'd say, out of this, the ugliness. I've also had situations, Glenn, where people come to me who are in a really good, committed dating relationship, and they know they're going to get married here soon to the second or the third spouse. And I'll talk to them about a prenup. And they're like, wow, they know they want to talk about it, but it's an uncomfortable topic. So I say, you know what I would do if I was you? Go over and see Glenn and get your estate plan in order just for yourself as a single person today. I know you're dating, you're not married yet, but go get your estate plan order and put the language in there that your estate plan has the prenup language kind of in it. So that way, before you get married, you can have that conversation and say, hey, honey, I have this estate plan that's been put in place and it requires me to have a prenup. Again, just try to find a way to bring this subject up, to get this done, to protect you and your assets, protect your kids, basically, without showing your new loved one the distrust. So you got any comments you want to add to that?
I just say, certainly every married couple that comes to me with it, when we have the trust at the death of the first spouse, if one of them remarries, I have that conversation all the time and highly recommend that we include that very language, because you're right, that comes in, we're getting ready to get married and the new spouse says, oh, how unromantic that, we have to sign a prenuptial agreement. I don't like this. And I say, well, if we don't, we lose access to this money over here. All of a sudden it becomes a lot more romantic than it was just a moment ago, right? Oh yeah, let's sign this thing because we're going to lose access. So it's just putting that in as a requirement of trust. That's why I say I can do things with trust I can't do with any other estate plan. You can't put that requirement on beneficiary designations. You can't put, that type of requirement in a will. The will only comes into play at death. So we really need trust in those situations. But it's important to address it and at least think about it. And if you choose that, no, I don't want to do those types of things. If we go into marriage, this is our money. And if I give it all to the new spouse, that's okay. That's fine. If that's your decision, just be very intentional about it. But what most people do who just don't even consider this stuff and they don't get around to the planning, it's unintended consequences. And that's what happened to my grandparents. When everything ended up, my grandfather remarried shortly after my grandmother's death, late in life. He lived only 3 months after he married. He died 3 months after he was married, and everything ended up going to that new spouse. And like I said, I wasn't in law school yet, but that stuck with me. When I got to law school, I was like, that should have never happened. My mom ended up getting a box of stuff that was put out on the driveway by the new spouse. She wouldn't even let us over. She'd made it clear we weren't welcome at the home. All of those things that came in.
You guys didn't even get the family photo album, right?
No, I didn't get photo. We didn't get to even sit in the family room at my grandfather's funeral. We sat out with the general public. She and her kids sat there. She was very hateful. I don't know why. We really didn't even know her. They'd only been married 3 months. They lived out of state. That was my first time to physically
knew what she was doing.
meet her. Oh yeah, she knew absolutely. She
knew what she was doing.
30 years younger than my grandfather too. She knew exactly what she was doing. But I think my grandfather just he didn't. And I know my grandmother's intent was not that the new spouse would end up with everything and her daughter would be left out. I don't think that was my grandfather's intent either. It was just not doing the planning. And so I just tell people, get the planning done, be intentional about this, review your documents on a regular basis, work with trusted advisors that will help you. If you don't have any, Mark, second your call to, feel free to reach out to us, but you need to look at the stuff. You need to get the planning done.
Well, to wrap this up, the third party of our community cafe here, who's not joining us here today, Chris Tillman, he's really supposed to be out of town on a major hiking trip across Colorado, and his trip got cut short. And so we kind of have a couple of these planned out where Glenn, you and I are doing several in a row without Chris, but Chris himself at First Option Bank has a tremendous amount of experience and knowledge on all of this topic here of dealing with a second marriage, a third marriage, blended families, transferring assets from one to the other. So, Chris kind of represents the banking side of the three of us, but he's also representing kind of like the trust department, a professional money managed trust department at a bank who manages these assets. So he's got a tremendous amount of experience from that, as I would do the legal side, the financial side, and then you have the legal side of that. So anybody, you guys have topics on this, whether you know us already or you don't know us and someone shared this video with you, please reach out through Facebook or however it's best for you guys to reach out and hunt one of the three of us down. If I end up getting the information, but it's not really relevant to me, it's to Glenn or to Chris, I'm happy to forward that over to them as well. So just important thing is reach out to us, get those particular questions answered on this topic. This is a big topic. I think I mentioned this earlier. If I didn't, I apologize. Did some statistics on this last week, looked this up in preparation for today. 50% of marriages end up in divorce. 100% of marriages end up in death. So, but 80% of remarried, 80% of people end up getting remarried. So this is a very relevant topic. And whether it affects us personally, it may affect somebody else in our family, it may affect somebody higher up in the family tree, or it's just some friends that we know or loved ones that we know. Got to share that kind of stuff. So let's wrap it up on that. We're at our 30 minutes. We like to try to stick within 30 minutes. Again, everybody, please share this video. Go to our Community Cafe Facebook page and like us so that way you can follow us on that if you would, please. Glenn, as always, buddy, thank you for joining me here today. Love your content. Appreciate you being a part of this and sharing your many years of wealth of knowledge here today.
Right. And for all those listeners, review those plans, update those beneficiary designations if you're in a remarriage or second marriage situation. Just take a look at that stuff. Mark, thank you very much. Appreciate it. And I think I'm seeing you next week on our topic next week. So,
yep, that's going to be a good juicy one. Trusted advisors, are they really a salesperson? Are they more of a business owner mentality? So we'll go deeper into that. All right, everybody. Thank you for watching here today. Be safe, be healthy.
All right. Take care. Bye-bye.